And now I would like to invite my colleague Alberto Pasino, I would dare say a true visionary, not just in autonomous field, but in other fields as well. Alberto, you will be looking at the issue from perhaps a little bit of an Italian perspective. And can you bring us into the subject matter, please?
Thank you very much, dear friend Miso, for giving me the floor and for the very kind words. And thank you to my dear friend Igor Vio for having me today with you to attend this very interesting panel. And thank you also to Fausto Ferreira for his very detailed presentation. First of all, I wish to try and share with you my video. Let's see if I can make it. Okay, there we go. So the reason that attracts so much attention and COREG is that among the international maritime law provisions, those rules present a wording which seems to hinder the advent of unmanned navigation more significantly. As we all know, they establish the steering and sailing rules to prevent collisions at sea and are relevant for the purpose of establishing the element of fault in the event of collision. Before briefly examining the most significant critical issues that the COREX reveal in relation to autonomous navigation, I would like to propose a general reflection. There are those who fear that the scoping exercise by the IMO Legal Committee could result in an attempt to predict the development of technology and therefore in an experiment which is not only infrequent, but also rather risky. Even though this fear should not discourage the IMO initiative in general terms, it suggests a reflection with regard to the COREX. It has been authoritatively stated that these rules are to be considered more a code of best practices rather than a code of laws, an affirmation that is based on their origin. The rules in question have in fact sprung from seafaring practices and customs. Therefore, if the COREX acknowledge good seamanship, thinking of modifying them even before autonomous navigation has appeared on the seas in a massive way, before its specific and critical issues have been understood, and above all, before the practices and usages related to it have been established, exposes to the risk, on the one hand, of wasting a great amount of energy, which may not perhaps translate into a genuine adaptation, and on the other hand, of not grasping and not regulating the actual critical aspect of the phenomenon, except only after tragic events have indicated the aspects that need to be regulated, as unfortunately has very often happened in the past. But let us see a few details, and I do apologize if I will go back to concepts that the paper presented before mine have been already dealt with. If we start with the general provisions relating to their field of application, since they address every vessel, the rules seem to appear neutral with regard to the existence of the crew on board. Nonetheless, beyond the intuitive ease of adapting some of their provisions to remote-controlled ships, the problem that arises on a principal level is how the general rules of good seamanship will be concretely applied to autonomous navigation. The proof of this is that the first critical issues emerge right from the examination of Rules 2 the one that appears to have the greatest importance among the codex. Such provisions establishes that good seamanship overrides a strict observance of the steering rules provided by the Correg, expressly clarifying the principle that in given circumstances, it might be mandatory to depart from the rules. The rule requires that the exercise of human judgment is contemporaneous to the decision-making process when steering a vessel, especially in those situations in which it is necessary to decide whether a correct prescribed maneuver is required or alternatively, a completely different one. In principle, this appraisal can be provided remotely as long as adequate data transmission and communication technology is available. And this seems to be, in fact, the most widespread view among the scholars, among whom the prevailing thesis is that the shore-based remote controllers, by assuming the responsibility for the conduct of the autonomous remote control ships, will be called to comply with the rules of conduct imposed by the Corregs, or to depart from them in accordance with the rule in questions, since they will be vested with the functions of command. In this perspective, the obligation established by Rule 6 concerning the determination of the safe speed will pass from the figure of the master to that of the shore-based remote controller. Therefore, the requirement laid down by Rule 2 would probably seem to be met both in case of remote control navigation and in that carried out through autonomous ships subject to permanent human supervision and of which it is possible to take remote control. Autonomous navigation performed without human supervision instead cannot fall under the rule in question in its current wording, and its rewording has therefore been suggested. Coming to part B, concerning the steering and sailing rules, Rule 5 is considered by commentators and by Mr. Ferreira one of the main obstacles to the use of autonomous ships, since its wording, and in particular the reference to the lookout, would seem to suggest that human person must necessarily be present on board for the purposes of its fulfillment. Actually, the main function of the lookout consists in collecting information concerning the ship's surrounding and in conveying this information to those who can assess it and make the decisions that are suggested by the relevant context. Therefore, it is a type of activity in which autonomous technology, insensitive to fatigue, loss of attention, or situational distraction, excels over humans. Nonetheless, the reference to sight and hearing seems to impose a human input in detecting and assessing the situation and the risk of collision. Therefore, with regard to remotely controlled ships, the problem is not particularly marked. The most recent autonomous vessels are in fact equipped with sophisticated audio and video sensors used to transfer the representation of what surrounds them to the person in charge of remote control, who will therefore carry out, with regard to the duty to exercise adequate supervision, the task currently borne by the master. This presumably satisfied Rule 5, preserving the role of human input in the appraisal process, in the sense that neither the use of electronic equipment, similarly to what already happens with regard to radars, nor the fact that the orientation takes place from the shore control station make their combination betray the spirit of the provision under review. Conversely, an autonomous ship using, for example, technology aimed at avoiding collisions, through the use of algorithms would not meet the requirement of appraisal through sight and hearing. Not even a future use of autonomous ships which, to avoid collisions, relied on automated systems to communicate their reciprocal position would seem to comply with Rule 5, which would suggest that the supporting role of the human factor should be retained as backup in the event of errors by the system. The last aspect to consider with regard to this part relates to Rule 18, concerning responsibilities between vessels. In particular, it gives navigational priority to the vessels which is not under command, defined by Rule 3, letter F, as that vessel which, through some exceptional circumstance, is unable to maneuver as required by the rules and is therefore unable to keep out of the way of another vessel. This rule usually covers vessels which have come into difficulty on account, for instance, of engine failure. When considering unmanned ships, the not under command status primarily evokes the risk of failure of the ship's communication system. The solution to problems of this kind could perhaps be identified in the use of appropriate signaling systems to inform of failure sea users in the vicinity of the vessel. However, the rules reference to exceptional circumstances seems to limit its scope to aspects other than the vessel ordinary operational arrangements, and this could perhaps make it difficult to maintain that the autonomous operability of the ship falls within the scope of the rule in question as it is currently worded. In summary, while the advent of remote control navigation and autonomous navigation under human control do not seem to require a radical modification of the codex to allow them to regulate the phenomenon, the same does not seem to be possible with regard to fully autonomous navigation, which is at present incompatible with their current wording. Having dealt with the issue of the steering and sailing rules, let us now consider those governing the collision between ships. Outside Italy, it has been authoritatively stated that collision law appears to be able to stand up well against the arrival of unmanned ships, based on the consideration that the 1910 Collision Convention governs the liability for collisions on the basis of the error of ships and not the errors of the master and the other crew members, even though these are of course the cause of the collision. And it has been also observed, however, only with regard to remote control navigation, that should the collision be caused by the error of a shore-based vessel controller, nothing will change regarding liability. In Italy, the position in this regard are less clear-cut, some doubting to court the applicability of the relevant law to remote controlled ships. A very interesting idea seems to be that of the author, who has recalled the efforts made by the European Aviation Safety Agency to attribute the responsibility for the operation of remotely piloted aircraft to the person who caused the danger of damage, regardless of any investigation of the qualification of human behavior or of fault. In this perspective, it has been observed that the navigation of a remotely controlled ship, albeit her command is held by a shore station, is kept under the supervision of a master appointed by the owner who has taken on the operation of the ship. And it has been noted that the assumption of the operation of the ship by the ship owner is a component that is present also in autonomous ships, given that also in this case, it is necessary to identify the person responsible for contracts, torts, and the obligation undertaken by the master with regard to the ship and the shipment. In this perspective, it has been deduced that once the person responsible for acts and facts of a non-contractual nature carried out by the unmanned ship has been identified in the figure of the ship owner, the rules on collision laid down by the Navigation Code will apply to him in accordance with the 1910 Brussels Convention, if and until a person is identified who has assumed the operation of the ship. The same scholar has nevertheless expressed the conviction that in the face of the full autonomy of artificial intelligence, capable of deviating from the initial parameters set by the manufacturer, we must revise the collision liability regime in light of the relationships between the vessel's manufacturer, the supplier of the controlling software, and the ship owner who takes on the operation of the vessel. This leads us to a conclusive reflection. Anticipating a very successful trend, Professor van Hooijdonk stated that with regard to autonomous navigation, the identification of new liability rules shifts to the legislative policy level, in which the possible scenarios are basically three. The first one is the shipowner's strict liability accompanied by the obligation of adequate risk insurance and direct action by the injured party. The second one is a strict liability of autonomous vessels themselves. The third one is the liability for fault of the software and hardware developers, of the system engineers, and of the builders of autonomous vessels. This same approach can be found in the academic papers that address the issue of the channeling of liability in the field of self-driving cars, where there are those who argue that given the autonomous thinking capability of artificial intelligence to the point of allowing it to deviate from the rules imposed on it by the manufacturer, it is possible to attribute legal personality to autonomous vehicles. Therefore, the question is not one of technique, but one of legislative policy. The reference to the vessel's fault contained in Article 3 of the 1910 Brussels Convention and the implicit reference to the common law doctrine of the personification of ships and its possible corollaries, first of all, the actio in rem, already explains that in technical terms, attributing legal personality to ship through fictio is a viable route, albeit distant from the civil law categories and from the continental perception. The issue on which we must reflect is whether, as well as possible, such a step is desirable. We must therefore ask ourselves whether it makes sense to imagine the attribution of liability to a ship without this corresponding to a fullness of her autonomy, not so much from a navigational point of view, but rather with regard to the channeling towards her of any interest and activity relating to the operation of the shipping company. This bears no accord with today's social and economic reality, and therefore the answer, to my view, should be negative, appearing at present more appropriate to channel liability towards the shipowner who assumes the operation of the ship. Now, I thank you very much for the kindness of your attention.
Alberto, can you hear me? Can you see me?
Of course I can.
I think I have around 25 questions for you. So I think the best thing is to, as soon as the restrictions are over, I promise I'll sit down in my car. I'll drive down to Trieste. We'll take a cup and B coffee, and then we'll talk about this
You're
issue.
so kind. Thank you very much.
Thank you so much. Very provocative and interesting introduction into a different views and how these different views may differ when considering what best means to apply in terms of responsibility. And talking responsibility and liability, we have two further speakers.